Now for what's trending in true crime, the Delphi murders case is winding down, and we're expecting closing arguments today, this morning. The defense resting its case Wednesday morning after several days of witness testimony. Richard Allen accused of murdering Libby German and Abby Williams back in 2017. The defense team has argued that there's no DNA, no weapons, no forensic evidence that ties Richard Allen to the killings. They also argued that the confessions that Allen made were false and the result of mistreatment behind bars. Each side's going to get 2.5 hours to deliver their closing argument. So this morning we're asking, what's left for each side to say? Here to discuss, criminal defense attorney and former prosecutor Anthony Osso, the co-host of the Deviant podcast and the co-host of the Down the Hill podcast, Andrew Iden, and criminal defense and civil attorney John Phillips. Good morning to you all. Andrew, I want to start with you, please. You are a great storyteller, and closing arguments are all about the stories, right? Who is delivering the better story for this jury as they go to deliberate? What do you think is left for both the state and the defense to say this morning?
Well, I think from a prosecution standpoint, Julie, I'm still waiting for them to say something that makes Richard Allen the number one, to close their case. They haven't really done that as far as I'm concerned, based on everything I've read and everything I've seen that's come out of the courtroom. The jury doesn't have, I don't think, a comprehensive picture of if Richard Allen is the guy that committed this crime. As far as the defense is concerned, I don't know that they need to say too much other than, look at all the facts that have been outlined so far. No DNA. The gun situation is a bit inconclusive. At the end of the day, if I'm the defense team, I may just kind of say, look, you've heard the story. The story is not a complete picture.
Right. No, I appreciate that. I think you're making excellent points here. So both sides get an equal opportunity to argue. They don't have to take all of the time. Anthony, also, tell me, what do you think would be the most effective way each side could go with these closing arguments, and what would be the big points you'd want to drive home?
From the prosecutor's perspective, I think to the heinousness of this act and invoke the emotion of the jury, because it's going to be a really hard decision for jurors to find that the man sitting in that chair didn't commit the murder of these two little girls. So I'm leaning into the facts. I'm leaning into the confessions. From the defense perspective, I think they've done a great job contesting every piece of evidence that the prosecution's brought forward. My job there, I think, would be to recognize the heinousness of this act, but at the same time, point out that every single piece of evidence the prosecution has brought forward has been contested, which would lead to reasonable doubt.
Mm-hmm. Right. And I like what you said there, Anthony, about recognize the heinousness of it, and where they're going is they got the wrong guy, right? John Phillips, take us home on this point, if you would, please. Big points for the state and big points for the defense. What will they make this morning?
Look, the defense is going to point to the amount of time that has passed, the lack of, again, the smoking gun type evidence. It's all circumstantial. They want me in prison. They've found the wrong guy, kind of a defense, and you wouldn't use all your time. Meanwhile, the state is probably going to use every dang second of their time, as they usually do, and do their roadmap. The closing argument, in law school, they talk about a roadmap. I'm 24 years into the practice. Sometimes I don't use the word roadmap, but I take people down the entire story and explain before the other side gets up and tells where my problems are, exactly what's going to happen and what I foresee they're going to say my problems are, and I fix them in advance.
Right. Exactly, John. Yeah, they've got to be crystal clear, to your point, which I love, and to underscore it. I think we've all been there, with juries where if it is not clear, plain as day, they're gonna walk whomever it is, because better to let, a guilty person go free than to incarcerate an innocent person. And so if the state isn't sure as can be that they've got the right person and it's got to come off that way and close, then they run the risk of a not guilty verdict. I want to pick your brains about another aspect of this, and it really goes to what the defense wanted to do, but what they were prohibited from doing. So there was an FBI agent who claimed that the girls' bodies appeared to have been moved and that the crime scene appeared to look moved and staged. And the defense theory was that this was a crime that was an odonistic ritual, a ritual killing. They talked a lot about odonism and people who, subscribe to that ideology. And they wanted to introduce experts on odonism to talk about different markings and things left at the scene that would indicate that this was some kind of a sacrifice. But the judge said no. The judge did not find that there was enough evidence to support that odonism theory. And so the judge said the evidence doesn't support it. There were many pretrial hearings and motions on this point. So the jury never heard it. They never heard that theory in this case. And so let's go back and ask the question, should the judge have allowed the theory to be presented and allow the jury to just give it whatever weight they may give it? Let's go back to our power panel. Andrew, I want to begin with you here, please, because you know a lot about this. You've really dug in, so kind of, I'm sure you could say a lot better than I could in terms of what the defense wanted to do here. Do you think that this was wrong, that they didn't have a chance to tell that story?
Well, look, I'll be the first to tell you I'm not a expert on odonism, nor am I a legal expert. However, I do firmly believe that when it comes to trying to figure out who killed two girls, especially in the heinous way that these two girls were killed, that the broadest scope possible is necessary. And if that means introducing odonism, the potential, and this isn't just kind of like a crazy theory. I mean, this is based on details at the crime scene, right? So if these details are at the crime scene, it's my opinion that you use the broadest scope possible and allow this stuff in. I'm not a legal expert. I don't know why this was not necessarily let in, but if it's up to me, my thought is if you can have a wide scope with as many of the details as possible, that only helps the system.
Yes, I'm with you. And nobody wants an appeal, right? If this guy's convicted, I'm sure John and Anthony, I read your minds, didn't I, gentlemen? That, let's dig into this. Anthony, so these closed hearings, we didn't even get to see the arguments about the odonism or the lack of the evidence because the judge shut out our cameras from everything. So, we're doing the best we can, to go in and report what we've got from the record. What do you think about this? Was this a mistake?
Again, I would have liked to be in the hearings, but in the end of the day, the judge is the gatekeeper of what comes into evidence and what doesn't come into evidence. And it is up to the defense if they want to put forth evidence on odonism to show, one, why it's relevant, and two, that their experts qualified to testify to it and how it's connected to the murder. So if they're just kind of throwing mud against the wall to see if it sticks and they can't really corroborate evidence to odonism or the type of killing that it was, then I don't think it was the wrong call. But again, I do agree with Andrew that I want to avoid an appeal, and I think the jury should have kind of the broad strokes of what took place so that they can make an educated decision.
Mm-hmm. Right. And John Phillips, take us behind the scenes a little bit. I know you were thinking appeal. Would you be having someone in your office working on this now, on getting the case law and the research?
Julie, I'm a flair for the dramatic. I wrote one word, appeal.
Appeal, look at you.
That's the only word I wrote. And,
how did I know?
I'm not going to slap it on my head like I've done before. There's certainly, the judge is the gatekeeper. And odonism is, and I had to look it up when I saw it, because I kept thinking of Marvel's movie Thor, because there is that. And I'm like, what's the tie? And it's this Nordic religion, and you do want to keep out stuff that's more prejudicial or sensational or a sidetrack or a distraction from the core issues at trial. But as a defense, that is it. Look, my client wasn't Odinist. He didn't follow Thor or whatever the theory is here. So, again, you would like to look at briefs, as a lawyer before you comment on things like that. And you would like to hear the hearings, but certainly appeal. I would have somebody working on nonstop.
I know you would.